Mr Blair.
My lady, can I first just pick up a transcript reference in answer to my Lady Justice Carr's query about properly arguable case, that sort of issue? We have found one point of relevance, if I could take you, please, to the Supplemental Bundle 2, tab 24, which is Day 2's transcript, at page 459 of the bundle, please. For Day 2, and it's page 19 of the internal transcript, pagination. Page 459 of the bundle, my lady, 19 of the internal transcript. And I want to just show you what the judge said at line 14, if I may, please, and onwards, where he's reciting that he said, I'm not going to be entertained further by a submission of no case to answer. So that I'd already told him by this point that I wasn't going to. And then he says, if there is a properly arguable case that the undertakings were breached, how realistic is it in the context of this abuse application, as opposed to the context of final submissions at the end of the trial, to be taking the view that it is likely to be only in that classification a technical breach as opposed to a breach of the undertaking where Mr Deripaska may well have realised it was indeed a breach. And then I say, top of page 20, I'll come on to explain exactly how I submit it arises. In particular, it arises because the unchallenged evidence will be to certain effects, and what I will submit is that it's clear that taken at its highest, the charge sheet against my client will not establish that he knowingly, deliberately breached it.
Right, so you were saying, I thought on this particular point, actually page 455, internal page 2, lines 2 to 10. You say, this is where you've informed your opponent overnight that you're not pursuing no case. You get in front of the judge and you say, I should first of all say, of course, I don't need to say this for your lordship's benefit, our decision not to pursue, that does not reflect a view being taken on the merits from our side. That is all for today. In another submission, and I think there may be one further reference, but is there any other relevant passage you can take us to?
Not that I'm aware of, my lady, thank you for that, but what I can say, given what I've just shown you, your ladyship, is that whatever I was trying to reserve my position on there, the judge took it that there was not being said to be, that there was being accepted to be a properly arguable case. That the undertakings were breached, and that was how he approached it, because we can see that's specifically what he said. I can't help you further, I'm afraid, with what else was. I don't think we found anything else on that. I'm just rereading what your ladyship showed me. Yes, well, I can't take it any further, my lady, except to say I do rely on what he said as having in mind that no one was suggesting there was not a properly arguable case. And in fact, he went on to consider, in that respect, as you see, whether how that would fit with an argument that the breach was technical or not deliberate, as I was submitting it would be on the basis of the evidence that was unchallenged from, in particular, Mr Valiev. Anyway, that was that. My ladies, my lord, can I just pick up then ground 1.1, just finish off? I don't really need to do very much more, I think, than to tell your ladyships and lordship which paragraphs are the paragraphs from the judgment where the judge criticised the non-prosecutorial approach that was taken in breach of what I submit is the proper approach that should have been, and as the judge found. And I'm going to just take this very quickly. Paragraph 142 of the judgment is where I'd start, please. And you'll see that at page 138. The judge says misguided that they adopted a stance that prosecutorial motive was irrelevant. And 145, where he finds from line 5 that the contempt application was pursued in an aggressive partisan fashion, as if it were just the latest round in the long-running no-holds-barred commercial litigation wrestling match. And 158 to 160, of course, where he says that the contempt application was presented to the court in a heavy-handed, aggressively partisan fashion that was inappropriate, vexatious and unfair to Mr Deripaska. Paragraph 159, where the
judgment certainly visits the alleged faults of Mr Chernukhin's lawyers on him.
Yes. Yes, my lady, that's a fair comment, and in my submission a fair approach for the judge, yes, because the opportunity was given for Mr Chernukhin to give evidence.
You're talking about the presentation of the case.
Yes, but presentation of the case, my lady, goes to objectivity and motive and everything that I've been arguing about this morning, in the sense that it represented a degree of partisanship on the part of the lawyers, the closeness to the client, lack of objectivity and distance. That reflected Mr Chernukhin's approach to the litigation as the judge found it. So, in a way, the judge does visit the matters on the lawyers, partly because only the lawyers gave evidence, of course, but partly because the very criticism was that they were too close to the client in advancing his vendetta rather than taking a more objective and appropriate approach. Paragraph 159 is where the judge criticises Ms Berard's 8th affidavit for being replete with tendentious comment, argument, irrelevant but prejudicial material.
Why were references to previous findings of dishonesty against your client irrelevant on an application for contempt?
Because, my lady, there was no allegation of dishonesty in the contempt proceedings.
But
there wasn't evidence of propensity.
It goes to moral turpitude, doesn't it?
Well, it's bad character evidence.
Whether you deliberately breach an undertaking. No?
Well, I would submit not, and the judge decided not. He said it was inadmissible bad character evidence. And on a proper quasi-prosecutorial approach, I would submit he was right. But your ladyship may disagree. What was being done, if I may say, my lady, was not an attempt to deduce evidence on propensity. It was an attempt to sling the maximum amount of mud in the most prejudicial and unfair fashion the claimants could muster. When properly read and understood in that context, I would submit that it went far beyond introducing inadmissible bad character evidence. In fact, it was designed to poison the judge's mind against Mr Deripaska before he'd had a trial. And that was the problem at bottom of the unfairness the judge found there to be. And then he said, and this is important because it was predicated on him having presided over the cross-examination, I regret to say that I formed a clear view that Ms Berard had come to argue the case for Mr Deripaska to be found guilty of contempt and had a poor, at any rate, variable grasp of the difference between evidence she could give, evidence she couldn't fairly give but Mr Chernukhin might have given if it were to be evidence at all but had chosen not to give, and advocacy. And he rightly deprecated that sort of approach from a solicitor in particular, I suggest, and also, of course, in a committal context. Para 160 applies a similar degree of opprobrium to the claimant's skeleton argument. If I can ask you to look at that, it was presented to the court as one in which there was no conceivable defence, barely a word of how the redomiciliation had been an instrumental element of a plan that saved N+ from ruin, to the very significant benefit of the claimants, though I infer that was appreciated at all events by Mr Chernukhin, and explains his lack of concern about the redomiciliation in prospect until RPC erroneously suggested.
Mr Pillow, that leads to one of the fundamental misapprehensions that the judge is said to have had about is the effect of the redomiciliation, in particular, its effect in relation to the shares as defined in the undertakings. Are you going to address that in a little
while on breach, if I may, yes.
Thank you.
But in my submission, it's not correct, my lady, to say it goes to that issue, because what the judge is there saying, essentially, is that Mr Chernukhin appreciated that the redom was really for his benefit because it saved the company from either nationalisation or ruin, which was a finding on the evidence unchallenged by the claimants. And if Mr Chernukhin did understand that, which he did, then the point my Lord, Mr Justice Andrew Baker was making was that explains why he didn't care as he saw the redom unfolding. And it goes, ultimately these points went to the idea presented through Ms Berard and the claimant's skeleton argument that the breach was both surprise, that this all came as a surprise, which was obviously which was the apparently intended effect of the evidence, and that it was clearly, seriously, flagrantly outrageous, because given the knowledge on the part of Mr Chernukhin, neither of those submissions was tenable. And then, my ladies, my lord, in paragraph 160, you get into the listing of what are 9, I think, particular examples of the claimant's clumsy and unfairly partisan approach, including matters, I won't go through them individually, but I'll just say the first item, little Roman 1, was said to be unfair to Mr Deripaska. Number 2 was plainly wrong in point of fact. Numbers 4, A, B and C were wholly inappropriate matters. And little a of that was irrelevant, little b was inadmissible, little c was oppressive. He then refers to inappropriate partisan passion in respect of item 7, including submissions, as the judge found, that should never have been advanced. And he gave one example of that at the end of item 7, which was that Mr Chernukhin, Mr Deripaska had only himself to blame because he was an international pariah. And that was said in submission. And the vice of all of this was not that, that it actually affected the judge's mind. It was that it was designed to prejudice or poison his mind, if they could do. And that in itself is not an objective that's appropriate in a case in which the civil liberty of the subject is at stake. But also because it evidenced the motive. Because it's by advancing a case in these terms, in part, that the judge was able to conclude that Mr Chernukhin was so motivated by revenge and hostility and so forth, and that his lawyers were prepared to adopt his vendetta to the extent they did, without being objective and without caring whether they were misleading in certain respects, which I'll come on to again in a moment. So it went to motive as well. And paragraph 161, top of page 146, so it's halfway through the paragraph, but at the top of the page, you'll see he says, the appearance in this case to him, and I stress again that he sat and listened to the evidence and heard it and read it all, and not just the selection to which this court's been referred. The appearance was of the claimants not seeking to put Mr Deripaska fairly on trial for contempt, but of claimants seeking to load the dice against him.
I mean, that sounds sort of fairly florid, but hidden in that sentence is not seeking to put Mr Deripaska fairly on trial. It depends what you mean by fairly. It goes back to the quasi-prosecutorial question, and seeking to load the dice against him. Again, this is all just a reflection of the quasi-prosecutorial question, isn't it? Because if you aren't required to adopt a quasi-prosecutorial role, then you can, as it were, put the case with one side's view in mind, if that's what he means by load the dice. I mean, if obviously you can't, tell lies, mislead the court, etc., etc. Nobody's suggesting that for a moment. But if it's a question of saying you can put your own case without having to, as it were, present the case for the other side as well, then it's no more than just reflecting his view about the quasi-prosecutorial nature of the process.
To that extent, I agree. It would really turn on whether I'm right or wrong on the quasi-prosecutorial
that was well demonstrated at the beginning of this whole section at 154, isn't it? All of this, 2 points, all of this is based on his approach, the quasi-prosecutorial approach, and it is clear that the judge had to relied on all of these factors together to reach his finding on abuse. So, for example, motive by itself is not sufficient.
I wouldn't accept that. The judge certainly said they were intertwined in his mind as to abuse, and that's right, my lady, correct. And motive appears at number 3, I think. But as I said, I think yesterday, even if he were in fact wrong on any of one of those heads, if I'm right on motive, that would be a complete answer to
Well, that's not what the judge found, because he could easily, in the way he operated, from the face of the judgment, you can see he would simply have said that is sufficient without more to dispose of the application.
He could have done.
And both in his oral comments, where we note with, he says in terms, for this and other factors.
Yes.
So anyway, that's how I read it, Mr. Pillow.
I'm not quibbling, my lady, with the way the judge expresses himself. I'm quibbling with the way the appeal would unfold and the case would progress if the court were against me on everything except motive, for example. And I accept that one might then have to, if you like, put Mr. Justice Andrew Baker's judgment to one side, and then say, we've got findings that are unchallengeable on subjective motive. The law is that if you've got the dominant or sole subjective motive as found by the judge, that's an abuse. And I would simply say, you would be saying the appeal fails, because in any event it's abusive for that reason.
That's very difficult, because as the test on appeal authorities demonstrate, decision as to whether or not something is an abuse is a holistic one. It's an evaluative assessment of a whole host of factors. Mr. Crowe would say including arguability and breach, and indeed you say no, put breach to one side. But isn't that right? It's a holistic overall evaluative assessment which includes the gravity of the misconduct alleged.
No.
No?
No, my lady. I mean, the authorities, such as, for example, the Stuart, Goldberg and Linda case, they say, for example, the merits in an abuse case are not relevant except if they're at the very extremes of the
either end,
spectrum. So you shouldn't be looking at merits.
All right, take a different example. Here, the judge clearly relied on misleading or dispassionate failure to act appropriately.
Yes. What you have to do, my lady, as a court, is to apply. Obviously, I'm saying this, but I know you know what I'm going to say. If the law is that an improper motive,
maybe, doesn't say definitely.
No, I
can't
accept
always
that.
be an abuse.
But if an improper motive, it found to be fulfill all the criteria I've identified, is improper, and the cases suggest without more is abusive, then
Then you say that's the end of it.
That is the end of it.
Whether he made other mistakes or not.
Yes, it is, and the same with the quasi-prosecutorial approach applies. But so my lady, I do struggle to see how you could be with me on the motive point, but still not uphold the abuse finding, because the merits can't come into it.
Well, you say.
I say, and the such authority as there is on that.
Well, the merits do come into it. Do you not say he had to accept it as arguable?
Yes, but that's a point in my favour, Melanie,
Right.
because
Yes,
obviously if they're not arguable...
So the merits are relevant to that extent?
As long as they're arguable, yes.
So because what you're doing is you're considering striking out an otherwise well-founded application alleging serious misconduct.
Yes.
So that's a relevant consideration, is it not?
Only only to the extent of accepting it as a well-founded or properly arguable point.
Right.
I accept that.
So you've got two things in play to start with: improper motive, decent case.
But decent case isn't... the decent case point, Melanie, only works in my favour.
When you say decent case, you mean decent case as to whether there was a breach or whether the consequences are serious?
I mean the former.
But surely the court can take into account the alleged
Consequences.
seriousness of the breach.
Yes, but they're tied together, Melanie. So the question on the merits is, has the claimant surpassed the basic reasonably arguable case threshold on breach?
Yeah.
And there's no dispute that. Now, once that's in play, that is not, the merits are no longer ground either way in the abuse argument.
And the gravity of the misconduct is irrelevant as well.
Yes, my lady,
Right.
because...
How can that be, for example? Take, for example, the court order which said you must, by 4 o'clock on Friday, provide an affidavit of your assets as a consequence of having a worldwide freezing order made against you. And the affidavit comes in 6 hours late. The breach of the court order, so, well-founded breach, maybe an admitted breach, but it's not, one would say, all other things being equal, a serious breach, especially if the affidavit, when it turned up, was full and frank.
Yes.
As opposed to an admitted, or at least arguable case of disposing of the entirety of your assets, notwithstanding the fact you'd been served with a court order, but just went on and did it anyway.
Well, the answer to that, I think, is that, as I've said, I don't suggest that in this case, if all the facts were made out and the law is, as my learned friend suggests, that the consequences would not have been serious. But once one is over that threshold, and if that's not the case, my lord, sector guard says you're in the wrong territory anyway. So if you only have a technical and non-serious breach, you're not even in the territory of sector guard. So it's a similar point to that I made to my Lady Justice Carr. That there's a threshold which is if it's all proven, is it serious? If not, it's abusive because it's a technical breach.
So the reason I took you up on it is I thought you'd answered, although the transcript doesn't pick it up. I thought you'd said when Lady Justice Carr asked you, and the gravity of the misconduct is, I think the word was irrelevant, i.e. she's putting to you what she thought I think your case was. And you said yes.
That's what I've written down.
Sorry, once you got over, yes. Both the merits and the gravity of the misconduct is irrelevant beyond the point at which you've established the merits are properly arguable, and if they're not, it's strikeoutable for that reason or abuse.
And by merits you mean, is there a breach?
Is there a breach of the order in our case? And I'm leaving aside the more complicated question of whether it's arguable that on the facts it was deliberate, because that raises factual questions that also goes directly to seriousness, but not so much to breach. And then I say the second threshold is the conduct capable of amounting to a serious breach, or the consequences serious? If so, well, if not, sector guard says, then that also is an indicator it's abusive. But if you're over that threshold, and I accept we are, that's the end of the seriousness issue.
Yeah, but you do look at the seriousness of the conduct.
If it's relevant, and all I'm saying is at the moment, if objectively it's accepted that the consequences would be serious.
But you have to tick the serious box, don't you, Mr. P?
Well, they have to get over the serious box.
Yeah.
And then
I'm not saying you.
Yes.
The serious box has to be ticked.
Yes. And once it's ticked, then one is into the question, right, okay, so it's got enough merit, and it's not a technical breach that would be knocked out on the first limb of sector guard, or second limb of sector guard. And then one applies the other things, motive, fairness. Is it brought to vex and harass? And one has to remember that abuse at the bottom, from the Henderson days onwards, is about vexing and harassing the defendant.
Absolutely, and vexing in that sense is always about bringing groundless proceedings. The heart of the jurisdiction to strike out for something being vexatious and frivolous is because it is without foundation.
No, my lady, not
Right.
at all. Not at all. That cannot be right, because abuse is used to strike out archetypally.
Abuse,
meritorious.
absolutely, but vexation, frivolous, vexatious.
That's a different point.
It is,
My
it
lady,
is, but we are using, so you're saying we're using vexatious simply in the context of abuse, not in the context of the CPR 3.42.
Yes, of course.
Frivolous and vexatious.
Of course.
That's
what I mean, vexation. And if one goes back to Lord Bingham's dictum in case's name I've instantly forgotten, Johnson and Gore Wood, which is the sort of epitome of the description of abusive process. He pins it to the unfair pursuit or the abusive pursuit of proceedings that are vexatious.
But why are you being vexed by proceedings if the proceedings are well grounded?
Well, my lady,
even in an abuse context.
if your ladyship were right, may I put it like this,
Yes.
with respect,
Yes.
then there would never be an abuse case when there was merit. And that cannot be right and isn't the law. And I might say, in this particular context, if your ladyship was right, then no matter how serious a bad motive the applicant
I'm not
has,
sure that's right either, because you could well be said, in a classic Henderson and Henderson case, to be vexing somebody a second time with what might on its face be a perfectly good case. In fact, it must be presumed to be a perfectly good case. But the reason that it's vexatious is you've already had one go, and you should have done it all together at the same time.
Yes, my lord, but that's just another example of why it's abusive. I don't. If an improper motive is a ground for striking out, and I accept that's one of the issues before the court, then it is right equally. Let me start again. If it is right that the stronger the case, the less likely it is to be struck out as an abuse. If the merits matter, if you don't strike out strong cases because they're abusive, then you would never strike out a committal, no matter how bad the improper motive is.
I think one of the problems I'm finding is it's all too equivocal. Unequivocal. It's black and white, and never this, never that. Isn't it all much more nuanced than that? And here we have a situation where 154, as I read, come together. That must mean cumulatively these factors render the application an abuse.
Yes. Well, I accept that, my lady, as far as the judgment goes. Right. I'm saying to your ladyship, I don't need to have them cumulatively, and you'll make of that submission what you will. What I am saying is that there's a great danger in my submission of your ladyship's approach, or the approach you're putting to me, I should say, really resulting in the fact that no case for committal can ever be pursued for too bad a motive.
It's part of the balancing exercise. It's quite a holistic assessment of whether or not, in the round, this is an abuse. Well,
in that case, you're going to have to, let's assume the only issues, my lady, were motive and merit. Unless the judge deciding abuse forms a view on merit, necessarily in the absence of the defendant's evidence, because he's not yet put it in.
Not necessarily, but potentially.
Well, I say necessarily if the Article 6 right is to mean anything, my lady, but you're right, potentially otherwise, but in this case that was what happened. Then
you're saying that merit would always trump motive,
yes,
and you be evaluating merit with your eyes half closed.
That's a perfect way of putting it. I'm very grateful to my lady.
Sorry.
Can I move on? It is absolutely right, then, my lady. I'm sorry, I got sort of lost my thought in the middle of the question. But yes,
I'm
that's
sorry
absolutely
to have spoken your words.
One does question if this case isn't abusive because of the motive, what case could ever be abusive because of the motive? On the findings the judge made of a sole subjective improper motive. What factors can be balanced in the weighing exercise that could possibly render this case appropriate to try and not to be abusive, if that is right? So that's my submission.
So to put it the other way up, you say that motive must always trump merit.
Yes, because merit can only matter to a low threshold degree, and because if it were otherwise, especially in a committal process, it would be unfair. And I do rely on those cases such as the Linda case, the Stuart Goldberg case, in a more classic Henderson situation, that say explicitly merits cannot be taken into account unless they are either demurrable or cast iron. And you can't have a cast iron case, of course, in a committal. You can't have a prima facie case that someone decides is cast iron without hearing the defendant.
Or in the face of an admission.
Of course, my lady. Of course. So, can I get back a little bit on track? But I'm grateful for that because I do think your ladyship's extracted from me the purest expression of what I'm trying to say on that. I was just taking you then, I think I got to paragraph 161, 162. 161 was the unfair loading of the dice rule. 162 is where the judge finds that Miss Berard for the claimants had lost or never had that degree of objectivity and detachment from her client that a fair prosecution of this contempt application with its quasi-criminal character required. That lack of objectivity infected the presentation of the case to the court through the skeleton. It was also confirmed by what cross-examination demonstrated to be a willingness on Miss Berard's part to allege dishonesty against Mr Deripaska in a new claim. And if you read on a little bit, he says the new claim on the basis of a document obtained by Clifford Chance in circumstances she had not investigated properly and in respect of which she could not say she had evidence for its authenticity. And that was another finding of fact that was quite important to the judge's view of motive and indeed, obviously, to Miss Berard's objectivity. Because what happened was a claim was issued seeking to reopen the arbitration on the basis that Mr Deripaska had run an entirely false case as to valuation, and it was relying on a document which was, frankly, an obvious forgery. But that didn't stop Ms Berard putting it forward to the court in support of that claim. And once the obvious forgery elements were pointed out, that claim was discontinued promptly by Mr Chernukhin. And it goes to reinforce in my submission the judge's factual reliance on matters that show the desire on the Chernukhin party's part to attack Mr Deripaska at all costs, without regard to the veracity of the allegation. And then paragraph 163, my Lord Justice Snowden mentioned earlier, is the I think is where he says that with the benefit of full argument, seeing Ms Berard's cross-examination, it was and is my clear view that quasi-prosecutorial judgment was clouded, leading to a process that was unfair. And of course I accept that that involves both the question of quasi-prosecutorial judgment, but also it includes the finding at the end of the day, which is what really matters, that this trial was not fair, would not have been fair. Now, can I just turn to one thing we haven't looked at, is the actual grounds of appeal. And I'm not going to dwell too long on too much, but I just want to show the court the grounds themselves, because there's a striking disconnect in my submission between the skeleton and my learned friend's oral submissions and the actual grounds that are enumerated in the grounds of appeal themselves, tab 2 of the court bundle. And there's a slight danger when reading the skeleton that the narrative sweeps away the detail as to what is actually being appealed and what isn't being appealed. I've just put that marker down. But we're on ground 1.1, and we're just about to finish hopefully on that. But I just wanted to identify that what my learned friends rely on as their private interest in the committal application is in paragraph 1.2c. And so this is what is said to justify taking a non-objective quasi-prosecutorial approach and doing what the judge deprecated. Firstly, little 1, it said that the interest was in the alleged breach having caused significant financial loss, for which they sought financial relief. That cannot give a proper interest in committal, because it is trite that, and we've quoted in our skeleton, I think, at paragraph 8.1, Lord Donaldson, Master of the Rolls...
So 1.2, page...
12.
12, my lady, yes.
Little c.
Little c, little 1. This is the first private interest is the financial one. And we've quoted the dictum of Lord Donaldson, proceedings for contempt are not intended to provide solace or compensation to the plaintiff. And that was, I don't think, actually very much challenged below. But it doesn't ground an interest in a litigant in seeking to send a person to prison. And that's why they, in fact, had to do the damages claim separately. And then the second supposed interest that justified taking the approach they did is little 2. And it said that the breaches were otherwise of direct relevance to related and ongoing proceedings between the parties in Jersey. Now, you've heard nothing about that. And in my submission, that cannot possibly found a personal interest justifying an attempt to send Mr Deripaska to prison. One of the reasons for that is that obviously if there was any wrongful conduct that's relevant to Jersey, then the Jersey courts can deal with it. The other is that Ms Berard herself...
Well, hang on, the Jersey court couldn't, for example, rule upon whether there'd been a breach of an English court order. I'd be extremely surprised if you managed to persuade a Jersey judge to undertake an investigation about whether there'd been a breach of an English court order.
Yes, well, what I mean, my lord, is that if there was a breach, the fact that it may be relevant to the Jersey proceedings doesn't justify trying to send him to prison.
Yep.
But there's a more important point, perhaps, which is that Ms Berard accepted that the substantive proceedings in Jersey were over as of the time of the committal. There was no further Jersey issue, and that's paragraph 100 of her 8th affidavit at bundle supplemental 1, tab 15, page 216. And the idea that it's in a person who wants to establish breach of something in a foreign jurisdiction has an interest in pursuing a committal application in England, and that justifies taking a non-objective approach, is now a respectful submission surprising. Can I just move on to say a few things about ground 1.3, please? And that's the ground, if you just turn forward in the document, the next page, that the judge erred in concluding that the claimant's alleged knowledge of Mr Deripaska's alleged breaches was relevant. So this is an attack on the relevance of knowledge, not the actual knowledge findings. The label of that is slightly apt to mislead, and I ought to draw your lordship and ladyship's attention to the fact that, in fact, although it refers to knowledge of breach, if you see in paragraph 4, what is being referred to is knowledge of the awareness of the redomiciliation, which is a slightly different and perhaps more important matter. And it was that knowledge, of course, in particular, that the judge had found was suppressed and improperly presented in the evidence in the committal application. Both the knowledge prior to the undertakings being signed off and the knowledge that the vote had happened in favour of redomiciliation in December 2018. Now, the findings in relation to this, I'm not going to go through, I don't have time, but just for the record, they are to be found in judgment paragraph 68 and 69. 68 is where the judge says that Mr Chernukhin on the facts.
Excuse me, I'm sorry, especially as one isn't allowed to cough any longer. So you said 68 and 69. 68
is where the judge found that Mr Chernukhin was aware of the active consideration of a redom, and he was untroubled by the possibility of shares moving from Jersey to Russia. And then 69, little 1, was where the judge concluded that it was precise. Mr Chernukhin spotted and read the article and emailed it to himself. That's the article in June about the possibility of the redomiciliation to Russia, precisely because it came out just as the undertakings were on the point of being agreed, being provided to the English court, which is an important finding of fact. And at 81, the judge said that it was therefore clear on the facts that Mr Chernukhin had the knowledge about the possible redomiciliation, and it did not trouble him, and he treated the undertaking as acceptable nonetheless. Now, all of that knowledge, therefore, was found as a fact on the part of the Chernukhin parties, and what the judge took objection to, rightly in our submission, was Miss Berard's signal failure in her evidence in support of the committal application to draw attention to the fact that that knowledge existed at all those times, and in fact her specific suggestion, misleading, positive suggestion, that it wasn't until May that this knowledge was acquired by the Chernukhin party. So if I could just ask you to turn up Berard 8, please, which is in the first volume of the supplemental article, at tab 15. And go to paragraph 61 first of all, please. I'll come back to paragraph 60 in a moment. Paragraphs before that in a moment. But 61, as I say, one has to bear in mind at this point that the judge has found as a fact that Mr Chernukhin knew all along about what was going on, including the vote itself.
Well, not it, and its consequences.
Yes, and its consequences.
Brought the redomiciliation and its consequences.
Yes. The judge found that Mr Chernukhin did know of the consequences, my lady. Right. So, well, at the very best, one can say that the "and" is very ambiguous in this sentence, because it does suggest that the redomiciliation itself was not within the Chernukhin party's knowledge at that point, let alone its consequences. But it's rather cute in my submission to say that they didn't know of the consequences until the letter, because shortly after the letter was written, they disagreed that those were the consequences. And Ms Berard said, in fact, that the shares in the Russian entity would be caught by the undertakings, or would continue to be caught by the undertakings anyway. So to describe that as having the consequences brought to their attention is also not quite right in that respect. And then in paragraph 66, one sees the evidence that, notwithstanding the undertakings, the Chernukhin parties were notified for the first time by RPC's letter of the 29th of May that B Finance had voted in to approve the redomiciliation. Now again, one can read that as suggesting that that was only a reference to being notified by the Deripaska parties. But in fact, properly read in the context where knowledge isn't mentioned at all, it conveys the clear impression, as the judge found, that that was the first time the Chernukhin parties in fact knew about the redomiciliation, which was wrong on the admitted evidence that ended up being extracted before the committal trial, before the trial. And then finally, in paragraph 105, is the point where Ms Berard makes a similar point in conclusion. Mr Deripaska's breach of the undertakings was first brought to the Chernukhin party's attention on the 29th of May, in circumstances where Mr Deripaska knew of the breach and its effect at the time of the breach. The delay of nearly 6 months in bringing it to the Chernukhin party's attention is extraordinary. Now superimpose onto that the fact, as we now know, that Mr Chernukhin knew of the so-called breach and its effect at the time, as the judge found. To say that that isn't misleading is pretty difficult in my submission.
I mean, the difficulty with this, these may be good points, they may be bad points, Mr Pillow, but what is clear is that Ms Berard, rightly or wrongly, is looking at everything through the prism of what the respondent, what your client did.
Yes.
So what in looking at his alleged misconduct, so why did he wait until May? Why did, when he knew all of this? That's why it's, well, it may be couched in the way that it is. Now that may be wrong on the judge's finding, but it's the way clearly the lens she looked at it.
I agree, and that's the problem, the lens she looked at it. And
but that's an error of law if you're right, and
no,
if the
my
judge
lady,
is right.
No, my lady. What it shows is that she was prepared to look through the lens of her client without objectively putting before the court the full and complete
Or what
picture.
she considered to be legally relevant was the respondent's conduct, not her client's knowledge.
Well,
you see what I mean?
that is one explanation for it. And the judge doesn't suggest that she did it deliberately, of course, in this sense. But he says that she was driven to it by the lack of objectivity. But I do ask my lady to ask herself, when Miss Berard came to court and the claimant's lawyers all said, oh, this is an outrageously clear, flagrant, egregious breach that happened when this vote occurred in December 2018. And by the way, they didn't even tell us about it until May. How can you seriously not think that the fact that you and your client knew all along about that was not a relevant matter to put before the court in an application to put a man in prison? And that's what it comes down to. And your ladyship will take or leave that as a point, but in my respectful submission, that's the vice of these problems, these paragraphs. And the judge finds in 156(2) that the same wrong impression was conveyed in Jersey. And this is relevant because it goes, apart from anything, it went squarely to Miss Berard's credit and credibility, but it also goes to motive. And you'll see at paragraph 78, the court will see that the judge finds that the Jersey court was told, in quotes, the undertakings would not have been agreed to had there been any suggestion of the company re-domiciling to Russia.
This is in the judgment.
Judgment, para 78.
Thank you.
Yes, that's right. So, and Miss Berard accepted that she had approved that to be said to the Jersey court in cross-examination. But we've already just seen that Mr Chernukhin himself knew precisely of there being a suggestion of redom re-domiciliation to Russia, because he sent himself the article to that effect precisely because the undertakings were being negotiated and finalised. So that, on any analysis, that is wrong and misleading.
And this was Clifford Chance again in Jersey?
Yes, that's right, Mary.
And same counsel?
No, it was local counsel.
Argument, or...
Miss Berard wasn't there, but she accepted that she had seen and read the skeleton in which that statement appeared, and that's why the judge rightly criticised it as going to the same point. This is not a question of comity and stepping on the Jersey court's toes and that sort of thing. It's the point that it was a good example and good strong evidence of the lens through which Miss Berard was prepared to project her client's case, being so careless, at the very least, as to be misleading. And the judge, rightly in our submission, said that's simply not an acceptable way to try a case in which a man might be sent to prison. Now, that's probably... Can I just then deal with the specific grounds of appeal on this topic, which are in paragraph 4 of the grounds, if the court still has that available in core bundle tab 2. There's just one point I'd like to pick up, please, and that's to take paragraphs 4C and D together, if I may. If I can introduce them like this, what effectively paragraph 4C says as a ground of appeal is that the claimant's case was not that they were unaware of the prospect of re-domiciliation per se, but they didn't appreciate the consequences of it until the 29th of May. And 4D says that the claimant couldn't have anticipated the consequences, the terms of which remained uncertain, etc., including a re-domiciliation to Cyprus. My submissions on this are these. Firstly, and this is an answer to both of those sub-paragraphs, one thing that no one intelligent could have failed to anticipate was a consequence of a re-domiciliation from Jersey to Russia, was that the company would become Russian and cease to be Jersey, and that the shares would cease to be shares in a Jersey company but would become shares in a Russian company. It's blindingly obvious and obviously axiomatic in the very concept. And so it's not clear to us at all what the factual basis is for the allegation that those consequences were not anticipated by Mr Chernukhin and the army of lawyers he had. And that's where the relevance of the other lawyers comes in, because one of those lawyers was a senior partner at Teare, who was a specialist, as the judge found, in a senior international corporate law specialist. That's judgment Paris 6, I think. And we know that's a Mr Adler from Miss Berard's cross-examination on day 1 at page 63. And the judge found that the assertion by RPC in the letter, the famous letter of the 29th of May, might have been a shock to Clifford Chance. It's paragraph 70 and 73 of the judgment. But he said that there was not an actual effect of the re-domiciliation of which the claimants were in fact unaware. That's paragraph 73. And in fact, he says there is no effect of the redom of which they were not aware long beforehand. And that is the context in which the judge specifically rejected Miss Berard's evidence after her cross-examination. If and insofar as, he said, she intended to suggest that she and her clients had no understanding of what a corporate continuance from Jersey to Russia was or how it would operate. That's paragraph 74 of the judgment. He in fact preferred to construe evidence in a way that didn't require him to reject it. But you'll see that in that paragraph. The second answer to these points is, well, it's an answer to 4C, I suppose, in particular, is that it's wrong, for the reasons I've really just given, to suggest that the claimants didn't appreciate the consequences until the letter arrived, because they did not accept the letter contained the true consequences. That's where I just need to show you, please, what Ms Berard said at the time about what the consequences of the re-domiciliation were in Berard 4, para 60, which is the first supplemental bundle, tab 6, page 87, please.
That's Berard 4.
It's Berard 4, my lady, yes, that's right. It was sworn on the 26th of June 2019. and the key paragraph is 60 for this purpose. There are others, but I won't go to all of them. If you see there on page 87 of the bundle, talking about the undertakings, Ms Berard says, in the course of his letter, Mr Vishnevsky, this is the undertaking letter, draws a clear distinction between the shares in N+ and the share certificates relating to the Jersey shares in N+. The undertakings referred to above relate specifically to the shares in N+, i.e. the second of the two of the dichotomy she draws. Consequently, the undertakings extend to the shares in N+ held by B Finance after the redomiciliation, i.e. the shares in the Russian entity, which will come to replace the shares in the Jersey entity, even if they are held in dematerialised form. And one does not have, well, that's what she said. So that is why the judge in para 74 of his judgment made the comments I have just referred to. He construed her evidence in fact as suggesting that it hadn't occurred to her that the redomiciliation would render the undertakings worthless, precisely because it would have, the redom would have effect so that the undertakings applied to the shares in Russia just as they applied to the shares in Jersey.
She obviously changed her position by the time of the contempt proceedings.
She had.
Yes. And
we say that well, she had changed the claimant's position, I think it's probably fairer to say. And we say that change was confected, because what's clear from both Berard 4, but the fact that they knew all about this as it happened during 2018 and into 2019 until May, shows that they can't have believed the undertakings were rendered worthless because they sat back and watched it happen.
What happens if the May 19 May letter is accurate? What impact would that have on all of this argument?
Well, I don't think it's anyone's case that it was accurate. It certainly wasn't below. And the judge found it wasn't, and it wasn't.
Sorry, I thought Mr Crow's position was the May letter was accurate and the June letter was accurate.
Well,
that's absolutely clear from his skeleton.
It clearly isn't. It clearly isn't. Well, it isn't accurate, my lady, because.
Well, let me make sure I haven't completely lost the plot. Is it Mr Crow's position? Is
You're absolutely right. That is our position.
Thank you.
The position is that, well, the letter can't be accurate because it's not in point of law accurate. But what really matters is that the claimant did not think it was accurate. In the respect that the undertaking still had value and were workable insofar as it attached to the shares that were owned by N+ in the Russian entity after it had redomiciled, as Ms Berard agreed in paragraph 60 of her affidavit. I think it is accepted that the share certificate element of the arrangements clearly fell away because the share certificate in the Jersey company wasn't relevant once the company had become a Russian company.
Mm-hmm. So back to my question. If the May letter is broadly right, or depending on how you approach value versus enforceability and all the rest of it, does that have any effect on the submissions you're making now?
No, my lady. I don't think so, and I'd have to think about it further if I had the time, but I don't think it does. Because, in a sense, what this head of complaint goes to is whether the knowledge on the part of the Chernukhin parties was misleadingly presented, and the relevance of it as a subject.
So we're now on knowledge.
Yes, exactly.
Not...
We're still in the relevant ground. Your ladyship is, if I may say, slightly anticipating the breach issue, perhaps. But I don't think it would affect my submissions on this point. Save to say that, of course, if it was in fact right that the consequences were as set out in the letter, then there is a question whether the claimants did appreciate those consequences.
Well, exactly.
You would say yes, that would have come as a surprise to them.
But they were, my submission is the suggestion save as to the certificates was so palpably wrong. That was why Ms Berard didn't agree with it straight away. And it was common ground, as the judge found, and I'll come back to that in a moment, between me and Mr Mill, that the shares continued to exist as shares, albeit they were Russian rather than Jersey shares.
You'll need to show me that, because that it was common ground, and explain it to me, because I don't understand that.
I've tried to, my lord. I've got what I've got to say about it, and I'll show you what there is. Right. But anyway, this is not on the question of knowledge, my lady. This is the question of whether it was right to say that the claimants didn't appreciate the consequences until the 29th of May, if it's correct, as the judge found, that they did in fact appreciate the consequences.
Well, it's so muddled as to what the consequences are at any one time understood to be. Anyway.
Well, it's not in this sense, my lady, muddled, that one has Miss Berard's quite clear statement as to the continued applicability of the undertakings to the shares in the Russian entity in paragraph 60 of her fourth affidavit. And you have Mr McGregor essentially agreeing with her in paragraph 75 of his second witness statement at page 113 of the bundle, at tab 7. And that was the position as one went into the freezing order application on the 3rd of July, or the security application.
And that witness statement went in, did it? McGregor too?
It did.
Yeah.
That was in support of the application to vary the undertakings. I said, I think, to the court yesterday, or end of yesterday, I think, that they it's. I'm just checking I've not mixed up my numbers. I don't think this was a specific answer to Berard 4. I'll be corrected if I'm wrong, but it wasn't. They sort of passed in the night, as it were, because they were for different applications. So there was agreement at that stage. And what we say has happened is, and we could see this, when we traced it through the evidence with the judge, that the focus was never on the share certificate at all by either party until more recently. What was the focus was on whether they could be enforced through the B Finance undertaking, which Mr Crowe had said back in 2018 was the critical undertaking, the B Finance one. He said to the court at that stage, because this will inform the question of direct enforcement, which I'll come on to in a moment, because the question about direct enforcement was always about how you would get B Finance to comply with its obligations, and that the proceeds of the shares would end up to the credit of the claimants when they didn't belong to Mr Deripaska. But I am slightly digressing, and I better press on. I was just looking at the grounds paragraph 4. Yes, I just wanted to pick up finally on this, the reference in paragraph 4C, 4D, to the fact that they say the claimants couldn't have anticipated the consequences of redomiciliation, which we frankly say is hopeless for someone as lawyered up as Mr Chernukhin was with his knowledge. The terms of which remain uncertain, perhaps in extremis, but not as to the basics and fundaments of what a redom is. And then they say they included the possibility of a redomiciliation to Cyprus, where enforcement could have been effected without undue obstacle. And that seems to suggest that had the redomiciliation been to Cyprus, there wouldn't have been regarded to be any great breach or serious breach, because you could still have enforced it. But that does, in our submission, obviously the effect of a redomiciliation to Cyprus would have had the same effect on the legal nature of the shares. They would cease to be Jersey shares and would become Cypriot shares, and the Jersey share certificates would fall away. But what appears to be being said is that it somehow might have been acceptable if it had gone to Cyprus but not Russia. In which case one has to ask, well, what is it that's being implied into the undertaking to keep the shares available for direct enforcement? And it's something along the lines of, well, you've got to keep them somewhere where it's not going to be too difficult to enforce against them. And that's not a clear and unambiguous requirement that could found an allegation of contempt. But it appears, therefore, that the construction of undertaking A, as it's called, has to accommodate, if you like, countenance the prospect of a foreign continuance, but only if it's not too difficult to enforce.
Right. I think what's being said here is, look, in practical terms, the claimants might not have been concerned. In practical terms, not whether or not there's a breach of the undertaking, but in practical terms, would a redomiciliation to Cyprus have had the profound effect that redomiciliation to Russia is said to have had?
Well, maybe that's so, my lady, but the fact that a redomiciliation was always on the cards and known to them suggests, in our submission, that they did not think, and it objectively isn't the case, that a redomiciliation would lead to a breach of the undertaking. Certainly not a breach of the undertaking to which Mr Deripaska signed his name, which is obviously is the important one. Now, 1.4, ground 1.4 is the errors of the judge in concluding that the claimant's evidence was misleading and inaccurate in other respects. I obviously don't have time to take you through all of the points set out in paragraph 5A and following, but I would urge of the grounds at tab 2, page 14. As I said yesterday, one has to bear in mind they are the challenged facts, not any others, and we've set out all of the answers to them seriatim in our skeleton argument of paragraph 16. So I'm not going to test the court's patience with repeating or embellishing what we say in writing, but we do say the fact that so much of the evidence was misleading and unjustifiably incomplete obviously went to abuse, both in the lack of proper quasi-prosecutorial approach, improper motivation of revenge and animosity, and more generally, that if you have evidence that is misleading, it may well be an indicator of an abuse of the court's process as an abstract idea. Of course, that's right. And what I would refer you to is Mr Mill QC, who could not, he said, and did not seek to defend Ms Berard's evidence root and branch. And he accepted, as did Ms Berard in cross-examination, that the tone of her statement and some of the hyperbole in it was indeed inappropriate. Now, one wouldn't expect the acceptance to go all the way, but that was quite a significant concession, and that was at day 2, page 175, lines 8 to 24. And really, before one can attempt the exercise of challenging the factual findings on the misleading nature of the material in these paragraphs, one has to obviously read the whole of the cross-examination of Ms Berard, the evidence that was adduced, or the material, the contemporaneous material that was adduced with her affidavit, and obviously, in particular, the RFIs, the requests for further information that we issued and were answered begrudgingly, as the judge found, and belatedly, to see that when you put all of the findings, all of the matters complained of by my learned friend, against the factual background, the judge was absolutely right to say they were misleading, or it was incomplete. One point I do need to pick up, and this is just an error, I think, in the grounds, and it infected my learned friend's submissions yesterday. 5C of the grounds, paragraph 5C, says that the judge's conclusion the claimant's evidence gave the very clear impression that neither Mr Chernukhin nor any of his advisors knew anything about redomiciliation was unsustainable on the material before him. The claimant's evidence expressly referred to the fact that the redom had been reported in the press in July 2018. That, I think, I submit and I believe to be factually false. There was no reference in the evidence to the press, and my learned friend, in fact, said that I think that was a reference to paragraphs 55 to 61 of Berard 8, and they don't say anything about the press either.
I think there is something.
I may have missed it.
In Berard 8.
I was looking at 55 to 61.
That may be a false reference.
Okay, I'm sorry about that. we have a look, but I'll do another search and see. Maybe my learned friend has something in mind in this error's affidavit. We couldn't find it. And anyway, errors slip into these things. I'm not hung up on that. The more important point, in a way,
Paragraph 55. No.
No, I don't think so, my lady.
No.
As I say, the most important point, I obviously my learned friend can correct that, then that's fine. But it doesn't matter really. References to the press reports are nothing to the point if, in fact, there is no reference to the knowledge to them having seen the press reports, which they had, and which material was only dragged out of them until at the last minute through the RFI process. And that's where the very opposite impression was given by those paragraphs of Ms Barrow's affidavit that I showed you earlier. Now, I'm going to just say a couple of words about breach in the time available. And I preface it by saying...
It's not alone. Paragraph 75 of Mr McGregor at page 113 says that, as far as he's aware, the continuance was not anticipated at the time the undertakings were entered into.
Yes, that's wrong.
Sorry, that's wrong.
That was wrong, yeah. Because once we've got the... yes, it was wrong.
Yeah,
but yes, but my lord, this is not a level playing field in that sense. This is an attempt by them to send my client to prison, and this is an example, if it's correct, of a failure to get it right and to present the proper picture. There's nothing to the point that later Mr McGregor comes along and says something also wrong, which is factually disproven by the time the trial happens. What is relevant is whether this casts light on either Mr Chernukhin's motive or the prosecutorial approach taken by
Quite interesting, isn't it? So Mr McGregor can act, as I'm sure he always would, as a responsible partisan solicitor acting in the best interests of his client, subject to all his normal duties as a solicitor. But on the other side, the lawyers have to act in a purely quasi-prosecutorial fashion.
Yes, because they're trying to send someone to prison.
Yep.
And that, in my submission, is axiomatic. And we say, if it were otherwise, entirely unfair. This is not a level playing field. Quasi-criminal cases are not the field in which a prosecutor can be slapdash and unobjective. That evidence, by the way, wasn't, I don't think, adduced at all in trial. For what it's worth, it had no causative impact. Breach, and I've got to be speedy. The reason, obviously, is partly because of my main submission on breach, which is that once one is in the realms of an arguable breach and one can ascertain objectively that the consequences are serious, would be if they were proven, then you really shouldn't get any further into the merits anyway, and the judge was right to do what he did. But you'll see from our skeleton, we do say the judge was right, actually, on the findings he made. But I would urge this court to be extraordinarily cautious in any conclusion or comment it felt it was necessary to make about the merits, if it is going to find against me on the abuse point, because, as I say, we know that the comments you make will be played back in aid of any subsequent committal. Unless they are caught by the undertaking, I suppose, that the claimants have already offered. And we do say that the judge was right to construe, you have to construe, as much as a principle, the wording of the undertaking in question strictly, and an injunction has to be certain, clear, and unequivocal, as Lord Justice Beatson put it when describing the strict construction principle in the Supreme Court, in the Court of Appeal, in the Bank of BTA and Ablyazov case, with which Lord Clark agreed in the Supreme Court at paragraph 19, which is Authorities Bundle, tab 20, page 429. And as we say in our skeleton at page 18.4, it is not a contempt of court if the breach of an undertaking is only a breach on one of two possible readings of the undertaking. The words must be clear and the breach must be clear beyond all question. And that's from Mr Justice Jenkins' judgment in Red Wing, page 71, Authorities Bundle 2, Authorities Bundle tab 12. And I would commend to the court the dictum of Lord Justice Wall in a case called Re-SC, which is quoted by Mr Justice Foxton in Integral Petroleum, at para 102, that's Authorities Bundle 29, page 672, quoting in turn from a case called In re Jones and Sir James Mumby, President of the Family Division, at para 21, where it is said, contempt will not be established where the breaches of an order which is ambiguous or which does not require or forbid the performance of a particular act within a specific time frame. The person affected must know with complete precision what it is that they are required to do or abstain from doing. And we say that on the best reading for the claimants of the Deripaska undertaking to make sure that shares remained available for direct enforcement is not satisfied.
Post the redomiciliation, the redomiciliation, were there any shares in EN Plus Group PLC in existence?
Yes, my lord, in the EN Plus Group, the
PLC.
Legal entity had become a Russian domiciled legal entity, but the legal entity isn't identified or formed by the initials PLC. That describes its existence as a Jersey company. But the company, it's a bit like, well, I would submit it's, if a person who is English moves to Russia, you're the same person, you're just not English. You might take on Russian citizenship. That is the nature of the company, and therefore the nature, we say, of the shares on a properly arguable basis.
The company may remain in existence, but a share, how can a share in a Jersey company be the same thing as a share in a Russian company?
Well, because, my lord, we say, and this was all in our argument before the judge, that the law of the place of incorporation of the entity, Russia as it now is, deems it so, and that is the effect of Jersey law in allowing it to go to Russia. And that is the reason why the shares are deemed in law to be the same shares.
Was it common ground?
It was not common ground, but it was not, I don't think there was any real argument to the contrary. And I'll show you a little passage where Mr.
But
Mill said...
all over Berard 8 was argument to the contrary.
Well, I'm talking about Mr. Mill and the way he put the case.
In her affidavit in support of the application for contempt, made it clear she was saying that the shares were cancelled. The shares as defined were cancelled.
Yes, that's right. That's what she said. But Mr. Mill said something rather different. And didn't push that point. I mean, that's probably as far as I can take it.
No, it's very, you're being
Can I show you? Can I show you what he did say?
Yes.
Perhaps perhaps I could start with Miss Berard's cross-examination. Take one to the position that she adopted at the hearing itself. That's at bundle 2 of the supplemental bundle, tab 23, please, my lady. And that's day 1 of the trial, page 438 of the bundle, internal page 152. And this, it may or may not take matters very far, but for completeness, I think it's part of the picture in which one might look at the question of common ground. If your ladyship and lordship see at line 4 of 152, Miss Berard says, so one of the points we're making in evidence, and this is by reference to Berard 4, was, the shares, the undertakings should also apply to the Russian shares. That was obviously still not satisfying in terms of the enforcement issues. Excuse me, but that is just to explain the statement in para 60. And Mr. Justice Andrew Baker then said, before we move on, just to unpack that, I might take the view that in a way there are 2 different aspects to that long sentence in para 60. One aspect is a statement of understanding about how the Jersey shares will come to be replaced by Russian shares, yes. And I think in part Mr. Pillow's main question was, is he right? Was your understanding at the time you saw this affidavit of how the continuance would work as a matter of corporate law and corporate share ownership? Yes, that is correct. So that was her evidence at the trial, But she did see the undertakings applying to the Russian shares as a matter of corporate law. And
I mean, hang on a second. What about 153? Turn the page.
yeah,
Question you asked her starting at line 7 and her answer through to line 15.
yes.
I mean,
How did this not offend privilege? Maybe no objection was taken, but...
Well, certainly no objection was taken, my lady, of course. Because Miss Sparrod had offered the evidence herself.
I mean,
she'd said what her understanding was, my lady, and that couldn't therefore give rise to a privilege issue. She'd volunteered it. Can I take your lordship's point? One then has a debate about other aspects. But I was trying to just ascertain what the claimant's position was about this as at
Yes.
the hearing, and I was going to take you to Mr Mill's submission about cancellation. And it's a small point because there's snippets here and there, and that's all I can show you, I'm afraid. Day 4 now for the submissions on breach. And my learned friend showed you page 75, I think. If we could perhaps just check that that's right. Yes, 74 to 75. That's where Mr Mill accepted that the shares as shares exist, but they are not the same shares in the sense that they are uncertificated shares in a Russian company. But he's not saying the shares as shares don't exist, but they're not the same shares. You'll have seen that at page 75 of the transcript.
I'm sorry. So I'm at tab 26.
Yes, my lady.
Is that step 4?
Page
And then
5
I'm
to
at-
8.
Sorry, 5.
2 8.
Thank you, I'm sorry.
No, it's my fault.
Yeah,
I didn't give you
I've
that
got
number.
it.
So that was shares. Essentially, I submit that he was saying the shares continue to exist, but of course they were different in nature. They were not certificated Jersey shares; they were uncertificated Russian shares. Of course, that's right.
well, I mean, it's actually wrong. It's a matter of English law. And in fact, you've got no expert evidence of any other law. As a matter of English law, shares are just a bundle of rights which are enforceable against a company, and they're subject to enforcement under a particular system of law,
Right.
subject to that domestic law.
Yes.
So by definition, a bundle of rights in a Jersey registered company subject to Jersey law is plainly a different bundle of rights than a bundle of rights which refer to a Russian registered company enforceable under Russian law. You know, a share is not a thing.
Well,
A share is a shares of action. It's a bundle of rights.
That's right, my lord. I accept that. My learned friend's analogy is that they started with a Rolls Royce and were left with a Larder.
That's not right either.
No.
And any more than your analogy would have been right if you... I know you were talking about a company transferring, legal entity, but the shares are very different things.
Well, my lord, I can't take that further. What I can say is that you say that I don't have and didn't have any expert evidence, and you're obviously right about that as a matter of Russian law. The Russian law deems the company to have existed from the date of its original foundation.
Yep.
And the shares in that company are the bundle of rights that relate to that company under Russian law.
I'm not sure it actually says that at all. The Russian law such.
I'm sorry, the Russian law doesn't say the second bit.
No,
I wasn't suggesting that. What I'm saying is that once you've deemed the company to exist under Russian law from the date of its foundation, the shares attaching to the rights in the Russian company are the shares that attach. The bundle of rights applies to that.
What Russian law actually, at least the extract we've got, says is that the shares in the Russian company have to have at least equivalent rights to the rights that existed in relation to the shares in the company of origin.
Yes.
But it doesn't actually say they're the same shares.
No,
or indeed they're the same rights, because they just can't be.
I'm not suggesting otherwise, my lord. But
That's what Mr Mill is saying at page 75, line 15.
Well, I think my Lord Justice Snowden is saying that that's not quite right either. But
No.
This
He's
is where...
saying, though, I'm sorry, that they're not the same shares. That's the last point he makes.
Yes,
I mean,
that's right.
It's very, I mean, perhaps...
Which is the bit that you say, Mr Mill goes...
Then yes, sorry, I was going to take you then on to the point specifically about cancellation, which was the debate in the letter and so forth, whether they were cancelled. And Mr Mill...
Well, the company is plainly cancelled because it ceases to be incorporated as a Jersey company, so that the bundle of rights that previously existed under Jersey law plainly doesn't exist anymore.
Well, my lord, I'm dealing at the moment with what Mr Mill
Sorry,
said
okay.
he was accepting about cancellation, and I'm the last person who's going to argue with your lordship about company law, especially unprepared to do it, because I say this is not particularly very relevant to this exercise.
But where are you
The passage
taking
I want to take you to is page 195 internally, please, bundle page 558. And it's simply that when the question of cancellation arose in the argument, Mr Mill didn't engage with it. He wasn't saying they weren't cancelled, they are cancelled. It's lines 9 to 13 of that page.
Of page
195.
Thank you.
So he says, then it was said, my lord, in relation to Mr Deripaska's undertaking, I'm starting too late. The fact that calling it a cancellation might not be absolutely on point. As a matter of detailed legal analysis is neither here nor there. That would be to allow your lordship to dance on the head of a pin if he was to be concerned about that matter. So the question of cancellation was not argued as a question of whether it was right or wrong, either in the letter or in any other evidence to argue about whether they were cancelled as such. His point was simply they wanted Jersey shares and they got Russian shares. That really is the way it went.
With 7 minutes to go, I'm going to have to ask this question, which is, neither you nor Mr Crowe have spent an enormous amount of time addressing what he describes as the overarching fundamental misapprehensions on the part of the judge. One of those is said to be the effect of the redomiciliation. If the judge was wrong as to his findings that the shares continued with the same shares, what effect do you say that has? And I'll ask the same question to Mr Crowe in due course.
Yes. If he was wrong, and one has to ask them very
ignore
carefully
breach,
what the question is that you're asking has to be very carefully formulated, because the judge, in some places, suggests that the shares were the same shares.
Yes.
Sometimes with capital S and sometimes not, I think.
Yes, but he's certainly at one spot, it says in terms, the shares as defined continue to exist.
Yes. And
if he's wrong about that?
If he was wrong about that, then any of his findings that depend upon that as a conclusion of law clearly are capable of being set aside or don't stand. And then one has to ask where they go to particularly and which findings they might upset.
Yes, and
But
do you say...
It's not a fundamental thing, my lord, no.
Right, so you say thank you.
Because, and this is where I'd just like to finish on the matter that occupied some time before the judge, which was the debate about whether, and don't forget the relevant undertaking talks about the underlying assets being 44.5 million shares in N+, remaining for direct enforcement. Those are the crucial words that you might say the construction exercise applies to. One has to work out what those words are. Are they clear, ambiguous, and do they tell Mr Deripaska exactly what he can and can't do? And there was quite a lot of evidence on that subject as to what exactly the parties intended to mean by available for direct enforcement. And if I could just deal with that.
How was that admissible?
Because, my lady, it was material crossing the line between the parties as to what they were seeking to achieve by their contract. Well, what they called a contract, but by the undertaking. It was plainly admissible and no objection was taken to it. Plainly admitted. The judge found, it's kind of, the question is, what is the mischief to which the undertaking is directed? That's obviously a relevant factor in considering its meaning. And the mischief could be discerned in part from the material before the judge as to how it came to be in the undertaking, as long as obviously you're looking at material that crosses the line and not subjective beliefs. And the first thing, what I addressed this, and the judge made findings on the basis of my submissions at paras 45 and 49 of his judgment, where essentially my submission was that the concern about direct enforcement was nothing to do with the jurisdiction in which N+ was or might be incorporated or become incorporated, nor indeed with the situs of the shares. But in fact, the evidence showed that the concern was to address the ownership structure of the shares in N+, to make sure, as my learned friend, my Lord Justice Snowden said yesterday, that these third-party assets were going to be able to produce money that had to be paid to Mr Chernukhin in the event of a breach, given that it didn't belong to Mr Deripaska legally.
Well, the evidence on that is extraordinarily mixed, in the sense that everybody knows who the legal owner of the shares was. That's clear. But the beneficial owner of the shares is at times said to be Mr Deripaska and at times said to be a company which Mr Deripaska owns beneficially.
But
and you can almost pick as many variations on those themes as you can have pages in the bundle.
But in fact, the understanding of the parties at the time, as one can see, was that he was the ultimate beneficial owner, but not the actual beneficial owner directly. So he didn't hold it under, he wasn't the beneficiary of a trust, for example, of the actual shares in person. What Mr Crowe showed you the structure, and at the top of it was a trust and some family interests.
Yeah.
And eventually Mr Deripaska was the ultimate beneficial owner of the shares. But that, of course, meant that if he defaulted on his personal obligation to pay the judgment, those shares were not, without more, available to be liquidated.
You'd have to cascade down.
You'd have to cascade. You'd have to go right to the top and start going through the trust. My lord, that was the issue.
Right.
To which the words in question, the heart of whether there was a contempt in this case, was directed.
But hence the point that you create an equitable charge by depositing the share certificates in relation to those shares.
No, my lord.
With solicitors in London.
That may be what in fact happened, but it was not the intention of the parties and the concern of the parties at the time that Mr Deripaska's undertaking was addressing. And that was a matter of evidence that was argued before the judge, and I can run you through some of it. And I've made the point. First of all, we had, I hope you saw overnight, Miss Berard's third affidavit come in.
Yes, thank you.
In which, that came from my learned friend, so thank him as well. That it was always being said by the claimants that the share certificates weren't relevant. They didn't matter. They didn't give them any extra comfort.
No, that's not what it says.
The affidavit.
Well, you'll read it and see what it
They're
says.
saying the fact that we've got share certificates in London doesn't mean that the location of the shares themselves is not relevant. So actually,
What they effectively say is, then this is tied with the fact that Mr Crowe, in his submissions at the time, said that the critical undertaking was not that share certificate lodged with the RPC solicitors, but the Wisniewski letter that bound B Finance to sell the shares and remit the proceeds to the Chernukhin parties in the event of a non-satisfaction of the judgment. And that is what, in our submission, a properly arguable meaning of the undertaking said to have been breached in relation to the positive obligation means. That they were to remain available in the sense that B Finance could have the obligation to sell them enforced against B Finance, so that they would be, the proceeds of them would be given to RPC for transmission to the Chernukhin parties. And those findings that I made, those findings the judge made about what was important being the situs of the ownership structure, was based on a whole raft of evidence, some of which you'll see me cross-examining Ms Berard on. For example, well, sorry, some of which you'll see me make.
But you've just said, haven't you just, what you just said is exactly right. You would, the enforcement would be against the shares, but the share certificates are held by RPC. So RPC will say to any buyer, we will only give you the share certificates, brackets, which you need to establish good title or to evidence your title if you give us the proceeds. You pay us, RPC.
No, my lord. The way it was envisaged to work and the point of this undertaking was that N plus, B Finance, if there was a failure to pay by Mr Deripaska, was bound to take steps to sell the shares.
Correct.
The enforcement of that promise was what the direct enforcement referred to, we say, in the undertaking. And that promise was always envisaged to be enforced, either in England, because then B Finance had submitted to the English jurisdiction for that very purpose in the undertaking, or in the BVI, where it was incorporated and could be ordered to act in a certain way. And that's also anticipated in the undertaking at Clause 7. In neither case was it anticipated that the enforcement of the B Finance undertaking would take place otherwise than in England and BVI. So what mattered for the purposes of the direct enforcement was that B Finance was on the line and required to comply and could be forced to comply if they refused. And of course that would take place in the English court or in the BVI court, either by an order they do something and then coercion, or replacement of the directors, theoretically, I suppose, in the BVI, or appointment of a receiver.
So on that basis, the RPC undertaking didn't matter.
Well, not very much, and certainly, my lady, what matters from now is that there's no allegation my client was in breach of the RPC undertaking. What matters is whether he was in breach of the undertaking he gave to keep the shares
How could B
available.
Finance sell the shares without delivering the share certificates to the purchaser, or procuring the delivery of the share certificates to the purchaser?
Well, my lord,
These are certificated shares. You execute a stock transfer form and you deliver it together with the share certificates.
you do in a Jersey company, and the question is when it became a Russian company, was that process impeded or obstructed? And in my submission, there's simply no evidence to suggest that it was.
Well,
Because what one would have to do, my lord, if I may, is anticipate that what would, and if B Finance refused to comply, the court would order it to execute the document required to transfer shares in Russia to a buyer.
the Russian court.
No, my lord. The court that had jurisdiction over B Finance. Because only the English court or the BVI court would be able to order B Finance to comply with its undertaking to sell the shares.
Right.
Whichever one, which is accepted, if it is, would apply to the Russian shares.
Right, but how does that get given effect to, bearing in mind that the company
Yes, is in Russia.
is in Russia and only the transfer of shares uncertificated can only therefore be given effect in Russia?
Yes. Well, my lord, the answer to that is that let's assume the court, B Finance do nothing and refuse to do anything, and the court appoints a master or the equivalent to sign a stock transfer form or whatever it is that you require to transfer the shares in Russia. The answer is that that document, signed, authorised by a representative of B Finance, gets presented to N Plus or the registrar of its shares, and the request is that the shares be transferred to the new buyer. There's absolutely no evidence in this case that that process was not going to happen, or there was a risk it wouldn't work. You don't get to the Russian court in this case because there was absolutely no evidence that if it came to it, the direct enforcement of the undertaking against B Finance would result in the execution of whatever is the equivalent of a stock transfer form in Russia that would transfer, when registered in Russia, the shares to the new buyer. And so one would not get, and the bottom line is, most importantly, a reasonable person in Mr Deripaska's position would not understand that he was prevented from putting this in place because...
Sorry, but you're I'm just looking at the undertaking. It's that the underlying assets, being the shares, remain available for direct enforcement. It's not direct enforcement against B Finance or anybody else. It's the assets which have to remain available for direct enforcement.
That is the very ambiguity, my lord, that is the problem. Because the shares were never available for direct enforcement against a debt of Mr Deripaska personally, except through the route of enforcing the B Finance undertaking. And as I say, there was evidence about all of this being the aim of the parties to try to resolve the problem. And you'll see in Miss Berard's third affidavit that the various problems she has with the undertakings being offered do not include that they can't be sold under that kind of enforcement process in Russia. And there is no evidence, and I do urge the court to bear in mind that on a committal, it's for the prosecution to prove beyond reasonable doubt that these shares would not have been transferred on the direct enforcement of the B Finance undertaking in the manner I've described. And I have run out of time, I'm afraid, but I do... My primary submission is one should not go down this wormhole, save to find, if it's necessary, that there is a reasonably arguable case.
Which you accept.
And I accept, and the judge proceeded on.
Now, where are you though with your submissions and the
I
grounds?
adopt, my lady, I'm finished. I adopt everything else I say in writing, and I say the judge was right in his construction, and certainly right to say that even if it is possible to construe them in the way my learned friend construes them, that is enough for me, because it has to be clear, unambiguous, and unequivocal. And if it matters, that's my submission. I'm very grateful for the indulgence.
Thank you.
Thank you very much indeed. We're grateful too. Mr Crowe.
My ladies, my lord, I've got a relatively large number of points, but each one of them is relatively short. So if I can rattle through. Just to begin, my learned friend opened with a certain amount on the factual findings that we are not challenging about, principally, Mr Chernukhin's subjective motivation and his knowledge of the redomiciliation. It may not surprise you to know that we don't like those findings. Mr Chernukhin doesn't agree with them, but I hope you will understand and accept that we have taken what we apprehend to be a responsible, realistic approach to the framework within which an appeal has to be conducted, which is that primary findings of fact made in the court below are difficult to overturn on appeal. So that is why we are presenting the argument we do in relation to the irrelevance of the significant findings of fact in relation to motivation, and why we are also inviting you to readdress things that are not primary findings of fact, but matters of judgment as to whether or not things were conducted in a fair way. The second point that my learned friend opened with to some extent was the question of, and the relevance, if any, of the no case to answer point. That in our submission is a red herring. In the event no argument of no case to answer was made, and it's important to recognise in this context that although my learned friend in the footnote to his skeleton in the court below reserved his right to make that point, the reading list that we included in our skeleton, it's in the bundle, if you want to look at it, but it's in, I don't ask you to go to anything now, but it's in the second supplemental bundle, tab 21, page 326. Our reading list, proposed pre-reading list for Mr Justice Andrew Baker, included Barrard 8, McGregor, and Mr Deripaska.
McGregor, the one that was subsequent to Barrard, January 2021.
Yeah.
Yeah.
And Deripaska 5. The skeleton from the other side didn't object to that. They actually included a footnote in their reading list saying we don't object to that. So the suggestion that there was any sort of a risk of contamination in our submission is misplaced, and the suggestion that we are deploying in the course of this argument material that wasn't in fact deployed in the course of the or available in the course of the abuse argument in the court below is, with the greatest respect, misplaced. So that is really all I wanted to say by way of sort of preliminary points. If I could just revisit the issues in the order in which I opened on them. So far as breach of the undertaking is concerned, the context of my client's concern about Mr Deripaska retreating to Fortress Russia with his assets where he is inviolable hasn't been challenged, and it can't properly be. The way that the material was presented to Mr Justice Knowles by Mr Fenwick, Queen's Counsel, can't be gainsaid. The most that has been said, and this is in picking up the question that my Lord Justice Snowden asked, and it's convenient to take it in the chronological sequence, is the remark in Berard 3 about whether or not it's significant where the share certificates are. And it's, with respect, important to understand the context in which that statement was made, the stage at which it was made, and whether ultimately that position was adhered to even. Because what you may have seen is that the Berard 3 is dated, I think the 16th.
20th of June.
14th.
14th of June.
June.
It's basically saying, looking at the undertakings then on offer, you can't make us feel better because the share certificates are with RPC in London. We're interested in where the shares are.
Yeah, absolutely.
Because they were presumably going to Russia or somewhere.
Well, the concern was, the context was that Berard 3 was actually made in support of an application by my client for a payment into court. What the position being taken there was, frankly, we are so exposed to the risk of non-enforcement of the judgment which we have got that payment into court is the only viable form of security. The response to that was, please accept these undertakings. Berard 3 says, well, we don't think these undertakings are good enough. The response to that was a letter from RPC, which you may also have received at the same time. And you'll see in paragraph 10 of that, they explain why they say an undertaking that includes the Deripaska undertaking, the B Finance undertaking, and the RPC undertaking does provide an acceptable package. That letter was written a couple of days later, I think on the 17th. We then turn up in court on the 19th of June in front of Mr Justice Knowles. Mr Fenwick says what he says in support of the viability of the undertakings as an acceptable form of security. And I won't go back to his comments about no risk of assets leaving England and Wales. That was the context in which ultimately the position was taken that this was a viable package of undertakings. But for the judge hearing this case to go back to Berard 3, which predated the point at which the undertakings were accepted, and say, haha, there's an inconsistency between Berard 3 in June 2018 and Berard 7 in August 2019, in our submission, is just an unfair approach to her. She was doing a professional job in June 2018 explaining why her client didn't want to accept the undertakings, and in August 2019 explaining why, in the event that had happened, it was considered that the undertakings had been broken. So that is context. We say the context is absolutely clear. The whole objective was to ensure that there were assets available in London. The key expressions that are used, and I think I'm probably merely emphasising by way of argument points that have been put to my learned friend in the course of his submissions. The key expressions that are used in the undertakings are not, with the greatest respect, open to different interpretations. The shares are defined as shares in a Jersey company. And the Deripaska undertaking B is to take all steps as are necessary to ensure that the underlying assets remain available for direct enforcement. The underlying assets can't mean anything other than the shares as defined.
Just going back to your submission about no challenge to the way material was presented on the importance of enforcement, what do you say to the point made very recently by Mr Pillow about paragraphs 45 and 49 of the judgment, where the judge says it's all about structure, not situs? Was that a different point?
I'm not suggesting that there is only one concern that is being met by the undertakings. I'm not suggesting that structure is unimportant. Structure was important, and that is why you need the three undertakings.
Right, thank you.
So I accept that.
But also it's all about enforceability.
Exactly.
You still maintain
the reason why structure was important was precisely to make sure that there was an effective mechanism for enforcement against assets in London.
And you say, do you, that the judge misunderstood? It wasn't about value, it was all about enforceability.
Exactly.
That's maintained.
That is it. And a point my learned friend just made.
Actually, technically, the assets are in Jersey. The certificates are in London.
Fair point, my lord. Absolutely right.
But the key was
not Russia.
The key was, whilst they remain certified shares, you have equitable security over them by the deposit of share certificates in London.
Exactly. And it is not, the point my own friend was trying to make just a few moments ago, was that he said that there was no evidence that enforcement against B Finance in relation to the Russian shares might not have worked. Well, that is, with the greatest respect, an irrelevance. We might well have had a fallback argument. Ms Berard may have been right in saying that the undertaking by B Finance extended to the shares in the Russian entity. She might have been right on that. But the point of the submission on contempt is that the operation of the undertakings was mutually interdependent, and what mattered was having an effective form of enforcement outside Russia in relation to these shares and not some other shares. And so the position we take in our submission is that nothing has been said in relation to the interpretation of the undertakings or the fact that what happened did involve a breach. Nothing has been said that should, in our submission, cause you to accept the approach taken by the judge. As just one point on common ground, what was or was not common ground, you were taken a moment ago in the supplemental bundle at tab 23 to page, I think, 438. In the course of the cross-examination of Ms Berard. I'm not going to read it now because it's 3 pages of transcript, but I do encourage your attention to page 437. Really, the whole of pages 145, 146 and 147. Because it is very difficult, I mean, what is being put by the judge to Mr Pillow there is, you're now saying that the May 2019 letter isn't true, aren't you? That's your case. And Mr Pillow, to do him credit, says, well, not quite, because we do accept that the RPC undertaking didn't really work anymore. It is not, therefore, common ground, even in relation to what Mr Pillow's position was, that the May 2019 letter was wholly incorrect. He was, in fact, in fairness, accepting that at least part of the May 2019 letter was entirely true. Namely, that the RPC undertaking was no longer appropriate, was how he put it at the very bottom of 146 of that transcript. Once the court has clearly in mind that these are not alternatives, the 3 undertakings are not alternative forms of enforcement, they are all mutually interdependent. The moment one goes, the others are useless. So, with respect, the entirely correct concession my learned friend made there in the course of that exchange does demonstrate, again, the judge's error in thinking that it was common ground that the May 2019 letter was provocative but erroneous. Just point of pure detail, there's been a couple of exchanges as to whether Berard 4 had been served before McGregor 2 was made. The answer is it definitely had been, because McGregor 2 talks about it. I don't ask you to go back to it, but McGregor 2 at paragraph 94, which is supplemental bundle 1, tab 7, page 117. He says, I've now got Berard 4. It's arrived after this witness statement has been drafted, but before it's been finalised. I don't have time to answer it now, but I think words to the effect that you know, at an appropriate time we can. So 2 points from that. One is he had received it. The second is there was subsequently no witness statement which denied what Ms Berard was saying in Berard 4, para 66, which is the point that I was relying on it for, which is our assertion of Deripaska control over B Finance.
Now, Mr Pillow says, can't read anything into that because Mr Deripaska had a complete right of silence, right to silence.
Yeah, well, he did, but we're not inviting, we weren't inviting the judge below to draw an adverse inference from Mr Deripaska's silence. What we are doing there and what I'm doing in front of you is asserting that, well, certainly what I'm doing in front of you, is submitting that the judge was simply wrong to say that our case on Mr Deripaska procuring the vote was based on speculation, because it wasn't. My learned friend said that McGregor 2 was not in evidence in the committal. McGregor 2 is the one that contains the supposedly ambiguous turn of phrase about Mr Deripaska voting the shares through B Finance. Now, it's very important to understand exactly what my learned friend means by using those words. It is true, McGregor 2 was not signed and filed in the context of the committal application. I entirely accept that. But the relevant paragraph from McGregor 2 saying, we acknowledge, or the respondents acknowledge, that Mr Deripaska voted the shares through B Finance in support of the resolution. That paragraph was quoted by Ms Berard in Berard 8 in the context of the committal application. So that piece of evidence, which came from the other side, was in evidence in the committal application, and it was never retracted by Mr McGregor. No doubt Mr Deripaska takes informed decisions about when to remain silent. But it is wrong to say that our evidence, that piece of evidence wasn't in the committal, and it is wrong to say that our a case on Mr Deripaska procuring the breach was not, our evidence that Mr Deripaska procured the breach was based on speculation. That's all I wanted to say on breach. Turning to abuse. Again, just taking matters in the order in which I dealt with them in opening. One of the things that we spent some time with yesterday was the question of what are the legitimate purposes for which committal applications can be brought. And in the course of debate with my learned friend, he accepted that the legitimate purposes are bringing to the court's attention a serious breach or coercing compliance. Those are legitimate purposes. Sectorguard sets those out. My learned friend said, I will try and get through these submissions where they're asking you to go back to bundles, because I think you're probably now relatively familiar. My learned friend took you to Sectorguard and said, look, here's some stuff that suggests that personal subjective motive is relevant. He said there were two reasons in Sectorguard for the committal application failing there. One was no reasonable prospect of success, and the other was illegitimate purpose. I don't ask you to go back to it now, but can I just try and encapsulate what we say you get from Sectorguard in relation to those two issues? The point in Sectorguard was that the undertaking that had been given was literally impossible of performance. And it was the mailing list, you may recall, that had been destroyed with no record of who'd been contacted. So that's the key finding, impossibility. What the judge then says is there are two, in a sense, legal consequences of that key finding. One is the committal application could not succeed. And the other is that it's an abuse. And it's an abuse because its purpose is not to bring a serious breach to the court's attention. It's a purely technical breach. So my learned friend in our submission doesn't get support for his proposition that subjective motive is relevant in determining what is or isn't a legitimate purpose. He has to accept that bringing to the court's attention a serious breach is a legitimate purpose. So in order for his argument upholding the judgment below to succeed on the issue of motive, what his case has to be is that an otherwise well-founded committal application, in other words, one that does bring to the court's attention a serious breach, becomes an abuse because of the subjective motive of the litigant in bringing that serious breach to the court's attention. None of the authorities say that. In our submission, it would be absolutely a wrong road to go down for reasons of principle and reasons of practicalities. On practicalities, you absolutely know that if this court gives the green light to saying, well, yes, an otherwise well-founded application for committal can be an abuse if the applicant really, really dislikes the defendant, you know every alleged contemner is going to take that as his preliminary point in any committal application. He's only doing this because he really, really hates me. So in practical terms, it would be opening an opportunity for that kind of preemptive argument. But it's wrong, as I say, in practical terms, we would submit it is seriously unattractive. But as a matter of principle, it's just wrong. As I say, it's wrong because if we accept that the two legitimate purposes for committal are bringing to the court's attention a serious breach or coercion, if you are bringing to the court's attention a serious breach, that is the purpose. The motive why you have for pursuing that purpose can't make a different purpose.
So are you saying that if that there's let's say, an obvious breach of a freezing injunction, and an applicant says in an unguarded email to the other side, I've just launched contempt proceedings against you because you breached the order, but if you pay me by way of settlement, I'll drop it?
Well, you've just beaten me to my next point. Because the one useful case that we would invite your attention to is one of the endless Abliazov decisions, Abliazov number 6, which is in tab 13 of the authorities. I'm not going to get it out now, but it was and actually in tab 14 as well, because there was an attempt to appeal and it failed. The point in Abliazov is this, and if I can try and encapsulate it rather than reading out the judgment. Once you've identified a legitimate purpose, what the court means by talking about an illegitimate purpose or a collateral purpose does not mean pursuing a legitimate purpose for a nasty reason. What it means is pursuing a purpose which is not the outcome which the court would deliver through the proceedings that you are issuing. So if you issue a committal application not in order to get Mr Deripaska to go to prison, but in order to blackmail him into a settlement he would not otherwise be agreeable to, that is an illegitimate purpose, because the purpose that you are pursuing, a large bung, is not the outcome that a committal application could deliver. So the contrast is not between a legitimate purpose pursued for a public-spirited motive as opposed to a legitimate purpose pursued for a horrid motive. The distinction is between a legitimate purpose and a collateral or illegitimate purpose, namely a purpose which is not the outcome that the court could deliver if the application were successful. So that is the clear distinction in our submission. And once you get that in, and it would be incredibly helpful, because there are a lot, as I think particularly Lord Justice Snowden pointed out, there is some fuzziness in some of the case law about using purpose, objective, motive. It would, this case is a tremendous opportunity for the court to deliver some clarity between, on the one hand, the objectively assessed purpose, and on the other hand, the motives that may underlie the pursuit of one of those purposes.
So the judge is finding, page 136 of Core Bundle, paragraph 137, in his oral ruling, his finding that the application was deployed not in order to draw serious misconduct and not to the attention of the court, it misses the point.
Exactly.
Even if that is right, that is his subject, that is the trigger. He does not want to draw, or he's not doing it to draw serious misconduct to the attention, but that is the effect and outcome of what he's doing.
Yes.
You say that is sufficient.
If the outcome of what he is doing is bringing to the court's attention a serious breach, and the outcome that is being, and the outcome in a sense that is being pursued, is the outcome that the court can deliver in response to that, namely committal, then the application is being pursued for a proper purpose, albeit for an angry motive.
So, if your client's motive in bringing the contempt proceedings was, broadly speaking, to ensure that if he ended up in prison because of the private prosecution, so would Mr Deripaska because of the contempt proceedings, that would be legitimate.
Yes.
But if your client's motive, purpose, whatever, in bringing it was to ensure that neither of them ended up in prison because Mr Deripaska would drop his prosecution, if your client was prepared to withdraw the contempt application, would that be an abuse?
If it was being brought in order to try and achieve an outcome that wasn't the outcome the court can deliver through the committal application against Mr Deripaska, that is capable of being an abuse. But that isn't the case that was put. Paragraph 28 of the judgment identifies the grounds upon which this application was said to be abusive.
We have the application.
Sorry,
Do we have the application?
Yes, it's tab 10.
Thank you.
But you'll see from 28.
Sorry, the application, the abuse application.
Oh, sorry, the abuse act. No, I don't think we do, oddly.
I'd like to see it.
I don't think in
Could
any
we-
of the bundles.
Could we have that? Do you mind?
Yeah, no,
Sorry.
I'd be perfectly happy for you to yes, I think it's not here. But the 5 headings of upon which the abuse is alleged are set out there, and it's not being said that there was a collateral purpose in the sense of trying to get the private prosecution dropped. So
and when the judge says at paragraph 103, he draws the inference and finds that the contempt application was a matter of tit for tat in revenge for the failure to drop the private prosecution. You'd say that what the judge is there saying is that because the private prosecution was not being dropped, i.e. there was a chance that Mr Chernukhin would end up in prison, he thought, right, well Mr Deripaska might as well end up in prison.
I'm going to
as
go
well.
down, you are too.
So, and you say that's legit because it's trying to achieve the result the court can deliver. And so the judge is finding that was an abuse was wrong. You say.
Yes, absolutely, absolutely right. Yes. And
whereas if it had been said it's a matter of tit for tat in order to pressure Mr Deripaska to drop the private prosecution, that could be an abuse.
Well, that couldn't have happened, could it? Because the CPS had taken over the proceedings and discontinued in March.
Yeah, exactly. But
So,
I appreciate on the facts.
no, well, I agree, but I mean that may well be, and because of because the facts were the facts, that may well be why the grounds of abuse didn't include that as one of the headings of alleged abuse, because it wasn't actually open to them on the facts to make that allegation. So that in our submission is the main point. What is legitimate purpose? What is illegitimate purpose? How does motive fit into all of that? And that also ties in.
Hang on, sorry, can I just get the time scale right? The contempt application was issued in November 2019.
Yeah.
At a time that was before the
Sorry, yes.
DPP took over.
Correct, yes.
Okay, I know. I think.
Well, look at 101.
100 and 103.
Oh, thank you. I'll just try and find. I know the prosecution was dropped in, I think, early 2020.
Yeah.
My fault.
No.
Yes, it's there in 103.
Oh, yes, it took over and dropped at the same time. Yes. That approach on the law on what is a legitimate purpose and what is an illegitimate purpose. Sorry, can I just pause for 1 minute? Just get. That I think leads conveniently into the next question, which is the question of the judge's approach in dealing with abuse without regard to the seriousness of the breach that was being alleged. And with respect, that is clearly what he did, because I think if you've still got the judgment open where we had it at 101, 103, what the judge says at 104 is...
and that's where you'd expect him to say, I make it clear that I proceeded on the abuse thing with the arguable case point clearly in mind, and the gravity of the sanction clearly in mind, but I had an open mind on the question of breach.
Yeah.
And Mr Pillow has helpfully pointed to that exchange between him and the judge on arguability. But there's
the position that was taken certainly in the skeleton argument in the court below, which in paragraph 71 of Vladimir skeleton argument in the court below, was that the Deripaska side was disputing the suggestion that that the application for contempt was being brought in order to bring a serious breach to the court's attention.
So this is now going back to the abuse argument.
Yeah, yeah, absolutely. I'm told we'll certainly get the application to strike out the committal application as an abuse in front of me, but on instructions I'm told that it doesn't actually contain any reasoned argument. It just says something to the effect, for the reasons set out in the first affidavit of Mr McGregor and the 11th witness statement of Mr.
Jonathan, it's in tab 11.
Oh, is it?
Yeah.
Oh, sorry. Oh, it is here. Sorry.
What we don't have is the witness statement.
Oh, yes, no, quite right. It's page 160 of the
Yes,
full one.
it
I
is.
do apologise.
Yes.
I somehow missed that.
No,
Yeah.
okay.
But we don't have the witness statements it refers to.
We do have McGregor's affidavit. We don't have the 11th witness statement of Mr McGregor now. But I'm assuming I was working on the assumption that paragraph 28 of the judge's judgment correctly summarises the grounds on.
Thank you.
And what's the relevance of the point you make about the respondent's skeleton?
Oh, sorry. The point was simply this: that being the stated position of the respondent in front of the judge below, if the judge was proceeding on the basis that he was going to decide the abuse argument on the assumed basis that, if proved, the matters alleged by the appellants did constitute a serious breach of a court order, or a serious breach of the undertaking, one would have expected him to say that that was the framework within which the abuse issue was decided by him, but he simply doesn't. So in our submission, it is apparent from what he says in paragraph 104 that he isn't actually taking on board the full gravity of what my learned friend's case has to be, which, as I say, is my learned friend's case has to be that an otherwise well-founded committal application, i.e. one which has a real prospect of success and is drawing to the court's attention a serious breach, becomes an abuse because of the motivation of the applicant and the way it's presented. And in our submission, the judge didn't actually face up to that as the point. And in our submission, that is where he does go awry. And it does matter, not just as a point of principle, but with the greatest respect to the judge below, it matters also for this practical reason, that if a judge, as this one did, decides abuse blind to the question whether there's been a breach, gives his answer on that, and then goes away to think about whether there's been a breach, Mr Chernukhin may well be forgiven for feeling that the judge, having said what he said on the 9th of June, this application is an abuse, might have infected the judge's decision on whether there was a breach in a reserve judgment he gave 6 weeks later. Judges are human, we all are. That is a possible vice. I'm not suggesting that in this case this judge reverse engineered his decision on breach, but it is a vice which in our submission should not be encouraged, because it is a potential risk. The next issue I just wanted to revisit very briefly was the distinction between civil and criminal contempt. There are just a couple of very short aspects to that which I wanted to address you on apropos of what my learned friend has said. The first was, in a sense, just to put by way of submission a point that my Lord Justice Snowden put to my learned friend in relation to the passage from Aldridge. It is not the case that any commentator, or case law for that matter, has suggested that there isn't a distinction between civil and criminal contempts. Our submission is clearly that there is plainly such a distinction, and it plays out significantly in the fact that interfering with the administration of justice is a matter in which the public interest is paramount, such that the permission requirement brings into play the question of whether or not the applicant is an appropriate person to have conduct of committal applications. The only point that my learned friend made in relation to that, which I just wanted to answer, is he points out that the categories of case in respect of which permission is required have changed under the new iteration of CPR Bar 81. And he says, well, it would be very, very odd if the test for requiring the public interest to be satisfied could vary in that way. And in our submission, that simply isn't a fair point to make. What has happened in the new rules is that you now no longer need permission to bring contempt proceedings where a false statement is made in a witness statement in High Court proceedings, which are still ongoing. Permission is no longer required there. You may infer, and we would invite you to infer, that permission is no longer required there because that kind of case in ongoing proceedings are precisely to be aligned with civil contempts involving breaches of court orders, because it is a case in which prejudice is being caused in ongoing litigation to another private interest litigant. So it's simply not a case in which a relevant, predominantly public interest purpose would need to be satisfied. The other point my learned friend sought to make in relation to the distinction between civil and criminal contempts, he says that where the need for coercion has fallen away, then there is no continuing private interest to be fulfilled, and therefore purely punitive civil contempt proceedings should be regarded as being matters purely in the public interest. Well, we invite you not to accept that either as a general proposition or on the circumstances of this case, because as you are aware, although the damages claim, as it happens, failed, the application for contempt was the corollary to the application for damages for breach of the undertakings in their contractual form. The two allegations were identical. And my client had lost in excess, I think, of £1 million by way of legal fees in Jersey and in London, advising in relation to what needed to be done in Jersey and the BVI in order to try mitigating what were perceived to be the breaches of the undertakings. So on the facts, it is not the case to suggest that my client had no private interest in pursuing the allegation. And in our submission, it is not an appropriate distinction of principle to draw. That brings me, in terms of the sequence of the arguments that I was dealing with, to the question of motive, but I think I have probably addressed you sufficiently on that. I don't think I've got anything further to add on that. So far as the next question, whether or not the judge was right to say that the prosecutorial standing of the applicant had to be exactly equivalent to that of a public prosecutor. And in our submission, my learned friend's argument, frankly, unravelled as he was making it orally, because he asserted that the function had to be equivalent to that of a prosecutor, but when pressed, had to accept that it didn't, in fact, have to be exactly the same as a prosecutor, because he accepted that there was no obligation to disclose unused material. We accept that there is, when one uses expressions like quasi-criminal, of course, I mean, it's useful in one sense, but as with most labels, it is capable of misleading. If one is precise about it, what the concept of quasi-criminal imports in relation to civil contempt proceedings is the fact that the charge has to be clearly stated, it has to be proved beyond reasonable doubt, and the alleged contender has a right to silence. If that's what one means, that's fine. But in our submission, there is no support for the proposition. And going to cases that do actually involve private prosecutions, the case of Hague and so on, do not advance the case that my learned friend is trying to run in support of the judgment below, that an applicant in relation to a civil contempt has all the obligations of acting as an entirely disinterested public prosecutor, because by definition that is not what the person is.
And you would accept, of course, that as in all litigation, one should be fair and should not mislead the court.
Absolutely. Axiomatic obligations, I agree, my lady, in all cases. Can I just check whether I need to cover anything else in those? There's just one incidental point. So far as the next point, the next heading was Mr Chernukhin's knowledge of the re-domiciliation. My learned friend spent a certain amount of time going through the evidence, saying that my client must have known what the effect of the re-domiciliation was. If my client must have known, it is difficult to understand why Mr McGregor, Mr Deripaska's own solicitor, didn't equally know. And since Mr Deripaska, not my client, was the person who had given an undertaking, it is extremely difficult to know why he didn't come back to court, having clearly, apparently, understood the effect, he clearly should have understood, as clearly as my client apparently should have understood the effect. It's difficult to understand why Mr Deripaska should not have been
At the
required.
moment, I'm not clear precisely what the judge found that Mr Chernukhin must have known in terms of consequences, because whether the consequences as the judge saw them, the consequences as you saw them for the contempt proceedings, or
Yes.
precisely what?
Well, I agree, and his findings on that are further, in our submission, contaminated by the fact that the judge does appear to have misunderstood what was common ground.
Will you come back to that contamination point, or is this the moment?
I think, to be honest, I don't think I've got anything really to add to what is already apparent, which is that paragraph 39, 69, and many other places where this point is repeated, the judge, at the very least, made an utterly illogical leap from the concession by, I think, Ms Berard in cross-examination and probably also Mr Mill in submission, that shares in a legal entity still existed. The judge made an illogical leap from that to assuming that the undertakings were unaffected by the redomiciliation.
So, assume for present purposes he was wrong about that, and that's simply for present purposes.
Yeah.
And what impact does that have on the abuse judgment in particular?
On the abuse judgment, it means that the argument, well, the third ground upon which we challenge the judge's finding on abuse, namely the relevance of Mr Chernukhin's knowledge of the redomiciliation, that element of our challenge must succeed, because if the judge is wrong about the effect of the redomiciliation, then the abusive element he found in Mr Chernukhin's knowledge of that supposed relevance cannot any longer be in play.
And what of the assessment of Mr Chernukhin's lawyer's performance?
Well, what I would certainly say, although I don't appear for chance in its personal capacity, it is certainly a factor in the judge's overall assessment of the presentation of the case, which was sort of visited on Mr Chernukhin. What we would submit is that the criticisms that were made of Ms Berard, and they are heavy criticisms, are entirely predicated on the judge's understanding of the legal responsibilities of a person presenting a case for civil contempt. And with the greatest respect,
if his understanding of the mechanics, I mean, there's one passage where he is critical of Ms Berard's sort of failure to realise that actually perhaps this contempt application should not have been brought at all,
yeah,
premised on his view that these shares were the same. So
yes.
Do you say that all of that is unravelled?
That unravels, yes. So actually, two aspects of the judge's criticisms of Ms Berard would unravel if you accept our legal argument. One is that, as I say, a lot of the criticism is predicated on his understanding of the function of an applicant in civil contempt, and the other aspect of the other predicate for his criticisms of Ms Berard are based on her supposed failure to appreciate that there hadn't been a breach of the undertaking. And in our submission, even...
I mean, that's a discrete reason why the merits come in.
Yeah, absolutely. Exactly. The only other point I think I haven't touched on, which my learned friend did deal with very briefly, this is mentioned in our grounds in paragraph 7C of our grounds of appeal, is that we do take issue with the judge below for his criticism of Mr Justice Teare for having said what he said, and for regarding what Mr Justice Teare had said as being irrelevant to the issues in front of him. Now, in our submission, both of those points are objectionable. With the greatest respect, Mr Justice Andrew Baker had no basis upon which to criticise Mr Justice Teare for saying, in the course of a reasoned judgment where Mr Justice Teare was being asked to provide additional protection for my client on the basis that there appear, on the basis, among other things, that there appeared to be a breach of the existing undertakings and therefore some new protection was required. With the greatest respect, to criticise Mr Justice Teare for having expressed a provisional view that it seemed likely there had been a breach of the undertaking and that that was a relevant part of the material which the court should take into account in deciding whether or not to grant additional protection to my client. To make that criticism is, with the greatest respect, simply unfounded. It was absolutely a legitimate part of the material Mr Justice Teare had to consider in deciding whether to grant further protection. Secondly, and as importantly from my client's point of view, whether Mr Justice Teare should or should not have said it, he did. He said, I think 3 times in the course of a not very long judgment, it appeared likely there had been a breach of the undertakings. How can that not be a relevant factor in deciding whether or not an abuse application that is then brought, a contempt application that is then brought, is an abuse of process? If a highly experienced High Court judge says it seems likely that there's been a breach, surely, with the greatest respect, that is a material factor for the judge to take into account in deciding whether it is abusive then to bring a committal application. We're not suggesting that Mr Justice Andrew Baker was bound by what Mr Justice Teare said, although that was an argument that was run, I think, in the application for permission to appeal, but permission was refused on that. The point I'm making is a different one, which is simply that it is relevant when deciding whether or not an application is abusive to see whether there are reasonable grounds for bringing it. And if a strongly and repeatedly expressed view from a High Court judge that you're right doesn't provide you with reasonable grounds, it's difficult to know what would. Can I just mention a couple of other very, very short points? I was asked, and I don't think I knew when I was asked, I can't remember if I answered, whether we had asked for a copy of the Argat Trust documents. I'm instructed that we did ask for it and it was refused. The only other point that I think I should deal with is, what are we asking you to do? And it seems to us that there are a number of different levels of sort of finality, so to speak, with which you could deal with this appeal, assuming that you are persuaded by some or all of what I have said. What you could do, in a sense, working from the bottom up, the least you can do, if you accept our argument, is simply to say, for whatever reasons you give, the application to commit was not an abuse, and send it back with no further guidance, so to speak, to be dealt with in the court below. Or you could rule on the correct interpretation of the undertakings, say there was no abuse, and remit it to the High Court to deal with contempt. Or, third option, you could say there's no abuse, rule on the correct interpretation of the undertakings, say whether there was a sufficiently arguable case that there had been a breach to survive the application to dismiss as an abuse, and then remit. Or, fourth option, you could go as far as saying that you could rule on the correct interpretation of the undertakings, rule on whether there was on the material in front of you a breach, and then remit to the High Court to determine the question whether or not there was contempt. And no doubt we would have a discussion about whether we would have to give an undertaking not to rely on your ruling on breach in the context of the contempt. All I would urge on you is that it may not come as a surprise to you to know that there is a very considerable amount of litigation between these parties, which shows no sign of abating. Certainly in the Jersey proceedings, Mr Deripaska is clearly going to make as much and has made as much of the finding of abuse by Mr Justice Andrew Baker as he can. In the interests of contributing to the finality of litigation, we would urge you to decide as much as you feel comfortable deciding, rather than take a minimalist approach. But I don't think I can usefully say more than lay out what I think are the sort of range of options. And as I say, seek to encourage you to be as decisive.
Just on the third option,
Yeah.
say whether sufficiently so no abuse, rule on correct we could of course dismiss the appeal, by the way.
Yeah. Indeed. You could add, sorry.
On your third option, no abuse or rule on correct interpretation, say whether of the undertakings, and say whether sufficiently arguable.
Whether there was a sufficiently arguable case of breach to survive the application to dismiss the contempt application as an abuse. To sort of include that as a reason, so to speak, for finding there was no abuse.
I see.
Unless there are any particular points.
No, thank you. I'm very grateful. I'm very grateful to both of you for your excellent and very, very interesting submissions. As you can imagine, or I'm sure you'll be relieved to know, we're not going to give judgment tonight. Also, I need not tell you, of all people, how it works from here on, but things will proceed in the usual way, and you'll receive a draft or drafts, and I'm sure you will only comment on matters which ought to be commented on, and will not seek to unpick those drafts. And when we come to costs, if you can't agree, and I was very naughtily going to say, I doubt that you will be able to, please ignore that. Then there will be written submissions in the usual way, and we will decide on the papers. Thank you very much indeed for this very interesting voyage that we've been on, put it that way.
Brilliant.